Yes, Mr.
My lords, my name. Before the short adjournment, I got on to reinforcement of domicile. I was going to take the court to the decision in Etihad, which itself referred to an earlier CJE decision of Meath, which is relatively well known, but it's worth looking at just for the reinforcement point. If I could ask the court to turn up Authorities Bundle 2, Etihad, as it's tab 12.
Yeah.
And relevant, in fact, one point I should just tentatively deal with before I go on to that is paragraph 61 of the judgment at page 345 of the bundle, which is the extract from the Bokar report. And my learned friend relies on the fact that Bokar refers to exclusive jurisdiction clauses conferring additional jurisdiction. The implication being it's only relevant where they grant additional jurisdiction rather than giving the same jurisdiction that one would have at domicile. In my submission, I mean, clearly, one of the purposes of such jurisdiction clauses is to confer additional jurisdiction where none would exist, but that is not the only purpose. And one cannot reasonably read the extract from Bokar's report as seeking to limit the utility or the purpose of a non-exclusive jurisdiction clause to that situation where it confers additional jurisdiction. Both non-exclusive jurisdiction clauses and exclusive jurisdiction clauses are used all the time to reinforce connections of the parties to particular domiciles. Sometimes they're not. Sometimes everyone wants to go to a neutral venue, and you have them in those circumstances. But very often they go towards a party, the domicile of a party or parties, or other connections with the performance of the relevant contract or the like. So in my submission, it's not right to say that a non-exclusive jurisdiction clause is only confers additional jurisdiction. It can confer jurisdiction to the court of the defendant's domicile, as well as other courts where there's no domiciliary link. But for present purposes, if I could ask the court to go to paragraph 64, this is the quote from the CJEU. But the decision in Meath, the case of Meath, concerned a contract which was between a German manufacturer of windows and a French, which was called Meath, and a French supplier of glass, which was Glacital. And the contract contained what was known as a reciprocal jurisdiction clause, which provided that if Meath were to sue Glacital, the French courts alone would have jurisdiction. But if Glacital was to sue Meath, the German courts alone would have jurisdiction. In other words, each party would only be sued in their courts of domicile, in the court of their own country. And the first question, which was referred to the CJEU, was whether Article 17 of the Brussels Convention, so the equivalent of now Article 25 of the recast regulation, permitted a reciprocal jurisdiction clause involving the courts of two contracting states. And the CJEU held that it did. And what was said, which is quoted, the extract which is quoted in paragraph 4, is that that wording, which is based on the most widespread business practice, cannot, however, be interpreted as intending to exclude the right of the parties to agree to two or more courts for the purpose of settling any disputes which may arise. This interpretation is justified on the ground that Article 17 is based on a recognition of the independent will of the parties to a contract in deciding which courts are to have jurisdiction to settle disputes falling within the scope of the Convention, other than those which are expressly excluded pursuant to the second paragraph of Article 17. This applies particularly where the parties have by such an agreement reciprocally conferred jurisdiction on the courts specified in the general rule laid down by Article 2 of the Convention, the predecessor to Article 4. So, now admittedly, Meath was a case of exclusive jurisdiction clauses, but the CJEU clearly accorded importance or significance not just to the autonomy of the contracting parties, although clearly that was an important factor, but to the fact that the contractual choice reinforced the domiciliary rule, and in those circumstances, objections couldn't be taken to the clause. And the court may also find some similarity between what was said there and the analysis of the Supreme Court in Aspen underwriting, with Lord Reed giving the judgment of the court, where the Supreme Court said, when one is looking at the Brussels recast regulation, you have to distinguish between rules or base of jurisdiction which derogate from the general rule of domicile and those which reinforce it. And when you're looking at rules which reinforce the basis of domicile, one doesn't necessarily get into a narrow
where is that?
interpretation. My lord, it's not in the bundle. It was just something which occurred to me as I was.
Which case is that then?
Aspen underwriting.
Oh yes. Okay.
The reference is it was last year, 2020, 2 weekly law reports, page 939, paragraph 57, judgment of Lord Reed.
Okay, we can look at that.
Great. But really, in my submission, that goes against the engagement of Article 33, where the contractual choice coincides with domicile, particularly where Article 33 wouldn't apply, where you were just in a contractual choice case and not a contract plus domicile case. Moving on then, if I may, to a separate point, which was to consider why it was in the first place that Article 25 is not referred to in Article 33 in the same way that Article 24, 26 and the privileged jurisdiction provisions relating to consumers and employees are not. And in my submission, the only possible answer is because of party autonomy, because the parties have voluntarily chosen the court, which is the subject of the clause, and for the purpose of the recast regulation, that is a good reason why there shouldn't be a stay in favour of a third state. So in my submission, all the articles which are left out from Article 33 are all cases where, if you like, the regulation assesses that there's a good reason not for staying in favour of a third state. And this is supported by Professor Briggs. If I could just ask the court to go to Authorities Bundle 1, and it's, here I may have the wrong reference. Tab 5 should be page 155 of the bundle, if I'm in luck. It is. It's paragraph 2.292. And he says, Article 33 allows the court to stay its proceedings if it is general jurisdiction or special jurisdiction in the matter before it, but not otherwise.
Yeah.
Insofar as the question is whether to cede priority to proceedings in a court in a non-member state which has already been seized, this limitation makes sense. For where the member state court has jurisdiction on the basis of exclusive, privileged or prerogative jurisdiction, there is generally a good reason for it to exercise it, which is, arguably, and now legislatively, more important than the fact that there are proceedings before the courts of a non-member state. And so, obviously, a non-exclusive jurisdiction clause allows the parties to select a particular court as having jurisdiction, and when one of them sues in that court, there is no reason to afford a discretion to stay in favour of a third state. And that being the case with Article 25 and Article 33, why should the position be different because of domicile, which is the sort of touchstone for Perform's case, that where domicile coincides, Article 33 does apply. Now, it's also in my submission important to note that none of Professor Briggs, Dicey, or David Joseph QC draw any distinction between an exclusive and a non-exclusive jurisdiction clause in the context of the application of Article 33. And we may just have to look at those quickly, if I may. Happily, they're all in Authorities Bundle 1, and Dicey, if we start at Dicey, that's tab 8, page 202 of the bundle. And this is taken from the Dicey supplement, which is obviously the bit that deals with the recast regulation. So page 170 of the book, it says, these new provisions, referring to Article 33 and Article 34, represent an important development since they expressly contemplate and seek to regulate the relationship between proceedings in a member state and proceedings in non-member states. They mitigate the rigidity of the decision of the European Court in Owusu as regards its potential impact on cases involving the prior pendency of parallel proceedings in non-member states, the problem highlighted in Catalyst. The solution adopted in Articles 33 and 34 differs materially from the rules on lis pendens and related actions that apply as between member states, under Articles 29 and 30 of the recast regulation, which is the point I made earlier to the court. He goes on, in the first place, Articles 33 and 34 only apply to cases in which the jurisdiction of the court of the member state is invoked on the general ground of the domicile of the defendant under Article 4, or on the basis of a ground of special jurisdiction specified in Article 79. The new provisions do not apply where the court of the member state exercises jurisdiction in cases involving a weaker party, insurance, consumer and employment contracts dealt with in Articles 10 to 23, nor do they apply where the court of the member state exercises exclusive jurisdiction under Article 24 or by virtue of a jurisdiction agreement under Article 25. So there is no distinction there as between exclusive and non-exclusive. And Dicey then goes on page 204, if one goes down to the start of the second paragraph, where it says, he's talking about Article 33 here, and it's described in the prior two lines as a rule of case management rather than a rule allocating jurisdiction as between member states. And it says, the position is different where the parties' jurisdiction agreement confers jurisdiction, whether exclusive or non-exclusive, on the courts of a member state. The power of the court to stay its proceedings in favour of proceedings pending in the court of a third state under Articles 33 and 34 applies only where the jurisdiction of the court is based on Articles 4 or 7 to 9. It does not extend to a case in which the member state court has jurisdiction conferred upon it by the parties to a jurisdiction agreement under Article 25. And he then cites UCP and Nectris, so again drawing no distinction as between exclusive and non-exclusive. And then finally, I'm not sure we need to turn it up as my learned friend took it to the court earlier, my Lord Flow, I think, noticed the point that in Joseph, and it's paragraph 10.80, he says that Articles 33 and 34 do not apply to jurisdiction asserted on the basis of Article 25 agreement. No distinction, again, as between exclusive and non-exclusive. So the commentators and academics don't draw a distinction between exclusive and non-exclusive jurisdiction clauses in the context of Article 33, and obviously neither does the wording of Article 33. And that would have been very easy to achieve had that been the intention of the drafters of the regulation. But in my submission, what Article 33 is a mechanism to allow a stay where the link between the member state court where the proceedings are taking place and say that the parties is weak enough to justify the member state court relinquishing jurisdiction in favour of a third state. So that's where there's only domicile or some other connecting factor such as the occurrence of a harmful event or place of performance of a contract. But where there's a jurisdiction agreement or there's exclusive jurisdiction because there's a claim in rem, in immovable property, or where the position is to protect what's considered to be a weaker class of defendants, so consumers, employees, then jurisdiction within the EU is retained, and it's retained despite the risk of irreconcilable judgments which arises by virtue of the pending proceedings in the third state. And it's really the level of justification for bringing the proceedings in the member state court, which is the overriding consideration in my submission for the application of Article 33. So in a case where the jurisdictional link with the second seas court, such as this court in this case, is strengthened, so where you have a non-exclusive jurisdiction clause and domicile, it's added justification, if you like, for not engaging Article 33, not for the contention of Perform, which is engaging it. Moving on to another way of analysing position, if I may, and I fully acknowledge that this is probably a more marginal point. I'm going on to Articles 7 to 9, because they are the other articles where jurisdiction is based on them. Article 33 applies. Because it probably just paid just to consider the position in relation to them, just to test the point. So if one is within Articles 7 to 9, obviously say there are proceedings before the court of a place where the contract is to be performed or the harmful event occurs, there's no domiciliary link from the defendant. Indeed, you can't have a domiciliary link, I think, from the express wording of Article 7 if it's going to apply. But the parties have also selected the relevant court where the where the proceedings are by way of a non-exclusive jurisdiction clause. In that circumstance, the court has jurisdiction under Article 7. it has jurisdiction under Article 25. And from the perspective of Article 33, there's no reason to say jurisdiction is based on Article 7 when the court also has jurisdiction by reason of a non-exclusive jurisdiction clause, because the parties have agreed that that court has jurisdiction. And Article 7, and this would be common ground, it's not a fundamental rule, it's not equivalent to the rule of domicile, it's not a default rule. No priority is exceeded, is accorded to it under the regulation. So it would sort of make no sense in an Article 7 case to say, well, the jurisdictional analysis, once the court has jurisdiction by virtue of Article 7, to stop there and say you can't go any further, you can't look to Article 25, you can't look to an Article 25 jurisdiction agreement. It makes no sense to do that, which is my learned friend's contention, and there's nothing in the wording or the scheme of the regulation which compels that result. And so in my submission, a non-exclusive jurisdiction clause cannot be irrelevant where the court has jurisdiction as well by any of Articles 7 to 9, because the defendant has consented to be sued in that court. And that is a far more immediate connection with that court than, say, the happenstance of the harmful event occurring in that particular jurisdiction in a tortious situation. And if jurisdiction isn't in those circumstances based on Article 7, where there's a non-exclusive jurisdiction clause, why should the position be otherwise when Article 4 is engaged by way of domicile? The wording based on is used in relation to Article 4, it's used in relation to Articles 7 to 9. There can be no justification in my submission for treating them differently, where jurisdiction based on Articles 7 to 9 cannot mean anything different from jurisdiction based on Article 4. Now, Perform's submission, sort of moving on if I may, is that one can't go beyond domicile at the place of domicile unless there's an ouster on the basis of jurisdiction. So it basically says that, right, the analysis has to stop right there once you're in the place of domicile and you're at Article 4. But there's simply nothing in the recast regulation to support that result. There's nothing in the wording, there's nothing in the scheme, and there's nothing in the interrelationship and the various provisions. There's nothing which says, you court of a defendant's domicile, you cannot consider whether you have jurisdiction by virtue of other provisions within the recast regulation. And in my submission, one can't use the sort of scheme or the purported scheme of the regulation as a sort of silent and unexpressed straitjacket. It's just, and when the commentators and Briggs are talking about it, it's just an explanatory framework to try and help people navigate the principles which are at play within the regulation. And in my submission, one also has to be careful about when one is talking about ouster jurisdiction. Because, of course, Perform says, well, unless domicile jurisdiction under Article 4 is ousted, one doesn't move on to Article 25. Article 25 is irrelevant. It has no role here where there's a non-exclusive jurisdiction agreement. But one has to be careful about distinguishing between, or differentiating between ouster, or rather more accurately saying where grounds for jurisdiction point away from domicile and where they reinforce the place of domicile. If one considers the rules, I think it's Articles 14, 18, 20, and 22, where proceedings are brought against a consumer or employee, and those rules or those grounds of jurisdiction provide that they have to be brought in the defendant's place of domicile. At the place of domicile, and one is always at the place of domicile because that's where you have to sue them. But on Perform's case, you have to say, well, at the place of domicile, does one go beyond Article 4 to go on to consider the position in relation to Articles 14, 18, or 22, in circumstances where those grounds of jurisdiction, they don't lead the court to a different destination than the court of domicile. They, as here, they reinforce the basic domiciliary rule. And so Perform might say, well, it's different because Articles 14, 18, and 22, what they do is they oust the Article 4 jurisdiction because because they sit higher in the hierarchy of provisions under the scheme of the regulation. But in my circumstances, it makes no sense to talk about that or to talk about ouster when the rule is the same. The rule is you sue in the place of domicile. And Perform wouldn't be arguing in a case involving consumers or employees that the court can look no further than Article 4. And yet, that's exactly the same position as this court is in, under a combination of Article 4 and Article 25. And indeed, in a consumer case, say the consumer is...
Well, it doesn't talk about ouster, does it? I mean, your point is that, it's a point that my Lord put to Mr Dewan, that Article 4 is the general jurisdiction. It's the first article in the general provisions. And it opens with the words subject to this regulation.
Yes.
So it internally contemplating that there will be other provisions within the regulation, which may mean that provision is not doesn't apply or isn't required.
Yes.
But it's not ouster. Nowhere does this actually use the word ouster at all.
No, it's one just sort of has to one, if you like, logically starts with Article 4 as the basic rule. Then one just simply has to look to the other rules of the regulation to see which apply and to work out from their language and purpose whether you apply them in addition to Article 4 instead of Article 4. But especially in cases where they lead to the same result, in my submission it makes no sense to talk about ousting out Article 4. There's simply no reason to do that. Really what the regulation is designed to do is to deal with conflict. And so you're not generally going to find specific rules which allocate jurisdiction to different places or really to deal with the position at all where there's not a conflict. And so, I mean, Perform says it's not incompatible, well, Perform says it is incompatible with the scheme of the regulation to conclude jurisdiction is not based on domicile at the place of domicile unless ousted. But I mean, apart from the wording of the regulation and how it's structured, I mean, it's entirely compatible to say that where jurisdiction is based on concurrent grounds, or rather, jurisdiction can be based on concurrent grounds. There can be an accumulation of jurisdiction, particularly where the additional ground of jurisdiction results from the contractual choice of the parties, and it reinforces the domiciliary rule. And in those circumstances, there's enhanced justification in my submission for this court retaining the case and not staying it in favour of a third party. And the final point I wanted to make, just in terms of how one tests the plausibility of Perform's case, is the interrelationship between Article 33 and Article 25, which the court has already sort of considered to an extent. And we say, and indeed the authorities say to date, that Article 25 supplies the contractually designated court with mandatory jurisdiction, and even in the case where there is a non-exclusive jurisdiction agreement, because that is, on a plain reading of it, what it says. Now, that was found to be the case in both UCP and the earlier decision of Citicorp. That was also the case in IMA, albeit that was dealing with an exclusive jurisdiction agreement. But one reason we say that is the use of the word shall have jurisdiction. It could equally say has jurisdiction, as it does in the French text. There's no material differences in our submission in terms of those two words. But it also arises from the fact that it says, or the text says, Article 25 provides the sorry, I read this wrongly. It's not simply the word shall. It's because it's phrased so as to say the English court or the court shall have jurisdiction or will have jurisdiction unless the agreement is null and void as to its substantive validity. Now that's actually a change from the wording of the original Brussels regulation. The words unless the agreement is null and void as to its substantive validity have been added. But in my submission, what that says and what that means is that unless the jurisdiction clause is invalid, the designated court will have jurisdiction under Article 25, and it's really that simple. Now, it's true to say that because of the way the regulation is structured, once the court has, or if the court has jurisdiction under Article 25, it can, in certain circumstances, have to give way to jurisdiction afforded to other courts. So in an Article 24 situation, where another court is given true, if you like, exclusive jurisdiction by the regulation, then the court, the beneficiary of the Article 25 agreement, has to give way to the Article 24 identified court. It would also be the case that if the jurisdiction clause didn't point towards the court of domicile of a protected class, so an employee and consumer, then this court would also have to give way. But save in those two scenarios where the regulation clearly says, actually, even though there's a jurisdiction clause, the contractual court has to give way, this court or the contractual court will have jurisdiction. The final point, really, which it's all gone quite quickly, but everyone's been fairly grateful for that, is just on the wording of the recast regulation. There's really just two short points, which I say probably do indicate that Article 33 does not apply in this situation. Perform obviously accepts that where there is an exclusive jurisdiction agreement under Article 25, jurisdiction is not based on Article 4, as Article 33 is not engaged. And we say that if the drafters of the regulation had wanted Article 33 to be engaged where there's a non-exclusive jurisdiction agreement, it would have been very easy to draft Article 33 to say that it applies where jurisdiction is based on Article 4, 7 to 9, or a non-exclusive jurisdiction clause under Article 25. And Article 25 does differentiate, doesn't use the word non-exclusive, but it does differentiate between exclusive and non-exclusive. So that point was clearly in mind for those drafting it. We also know that the drafters of the regulation had the distinction between exclusive and non-exclusive jurisdiction in mind when they constructed the lis pendens provisions as they apply to intra-EU cases. Because one sees at Article 29 that where proceedings are involving the same cause of action and the same parties are in the courts of different member states, the second seas court must stay its proceedings in favour of the first seas court, save that where Article 31 subparagraph 2 applies, which is where a court has exclusive jurisdiction under Article 25, the first seas court has to stay in favour of the second seas court because the second seas court has exclusive jurisdiction. So Articles 29 and 31, when you're looking at intra-EU lis pendens, specifically differentiate between the effects of exclusive and non-exclusive jurisdiction clauses. And yet, when you get to Article 33, no such distinction is recognised at all. And in my submission, that's a powerful indication that there's simply no intention to distinguish between the two types of jurisdiction clauses for the purposes of Article 33. The drafters of the regulation have managed to do it a couple of articles earlier. If they'd wanted to do it in Articles 33 and 34, they would, of course, have done it. They didn't.
And it's significant in that context that 31.2 was new as well.
Indeed, that's right. So you have the new provisions in 25, 33, 34 and 31.2. Those are really the sort of the greatest sort of new sort of innovations within the recast regulation, save for the arbitration provisions, of course.
Yeah.
Unless I could assist the court further on that aspect of ground 1 of the appeal, I was going to move on to ground 2.
Sorry, can I just put one very small point really on Article 25? You pointed out that the wording of the saving, unless the agreement is null and void as to its substantive validity, was new. And you may have said this, so I apologize. It's admittedly perhaps a slight indication that the introduction of that proviso so worded is itself an indication that the words shall have jurisdiction are meant to be mandatory. Because if it were just merely permissive, I mean, you wouldn't really go out of your way to make an exception for a case where was the agreement in question, sorry, was null and void. That kind of an exception only makes sense to an absolute, an otherwise absolute rule.
Yes, yes. I hadn't thought of that point, but my lord
Well,
is
it's only a small one, but I
no, but
throw it
I
out
take
for
all the
what
help
it's
I can
worth.
get. Absolutely, no, I'm grateful. And actually, in terms of other wording, just for the court's note, in terms of Article 25, regardless of their domicile, was also new wording, because the previous version of this article in the original Brussels regulation was confined to domiciliaries of member states.
Yeah.
Yes.
And then that was
And also
expanded.
Article 25(5), which I think must also be a new severability provision.
I believe so.
But again, that second paragraph, the validity of the agreement conferring jurisdiction cannot be contested solely on the ground the contract is not valid. Ties in with the point about unless it's null and void.
Indeed,
It's the same.
consistent with that interpretation. And just for the court's note, the original Brussels regulation and the Brussels Convention, if one needs to sort of track through the provisions, are included behind the recast regulation here. And actually, at first instance, we had produced a note so that the judge could track the provisions across the various EU instruments, which was helpful, which we can...
So is that tab, behind tab 3 is regulation 44,
That's right, that's the original.
2001,
That's the original Brussels regulation. And then behind that on tab 4 is the Brussels Convention.
right. Yeah, okay, thank you. Yeah.
So, recital 24, the proper, necessary for the proper administration of justice. I think the first point taken by Perform is as to the relevance of risk of irreconcilable judgments within the phrase proper administration of justice. And they say it's been put slightly differently orally than it was in their skeleton argument, as to which there's no criticism. But I think in their skeleton they said that proper administration of justice goes beyond the risk of irreconcilable judgments. While they accept that, the risk is a core feature. As it's now put is that in effect where the conditions, the threshold conditions for Article 33 are fulfilled, so the triple identity test, there is a prima facie case for a stay when the Article 33 threshold criteria are fulfilled. What we say to that is firstly, and the court has already looked at recital 24, but it obviously and specifically refers to all the circumstances of the case. And in our submission, there's simply no reason or basis to narrow down that wording. And given that, we also say that it isn't necessary or helpful to identify risk of irreconcilable judgments as a core feature, let alone giving rise to a prima facie presumption, if you like, sort of in favour of a stay. I mean, there were obviously various options available to the drafters of Article 33 and 34. They could have gone down the Article 29 route and imposed a mandatory stay. They could equally have imposed a presumption of a stay once the threshold criteria were met, but they didn't. Rather, you have this sort of very extremely broad and open-textured expression, which was afforded by virtue of recital 24. Secondly, Perform says that the judge fell into interpretive error in having regard to connections with the member state rather than having regard only to connections with the court of the third state. And it was also said that there's a deliberate choice in recital 24 not to refer to connections with the member state. But in my submission, that simply cannot withstand the clear and express wording of recital 24. And it may be helpful just to look at what Briggs and Dicey say about this, because the court hasn't seen all of the relevant passages. But what they are all quite clear about is the breadth of the discretion which is afforded to the court sort of undertaking this task. So first, if we perhaps look quickly at Professor Briggs, which is at tab 5 of the First Authorities bundle. I think it's page 203 of the... Oh no, that's... Forgive me, that's Dicey. Tab 5, page 156 of the bundle. And the court was taken to the first passage at the top of that page, where there's the sidelining. But then I would just also ask the court to read the second paragraph following it, which starts, when considering whether to order a stay of the proceedings before it, the court is entitled to consider all the circumstances of the case, but recital 24 makes particular mention of factors which, were they to point to a member state, would give that member state exclusive jurisdiction. Insofar as this means that the proceedings in a non-member state are in a court which mutatis mutandis would have had jurisdiction under Article 24 or 25, it is welcome. As will be seen below, little good will come from failing to treat jurisdiction agreements for the courts of the non-member state as institutionally inferior to those for member states. Now, that is true for jurisdiction agreements. It must be a fortiori for connections of the kind indicated by Article 24. And it was that passage actually which was one of the reasons why I thought that when one looks at the second paragraph in recital 24, when there's that reference to exclusive jurisdiction, that it is actually referring to both exclusive jurisdiction under a jurisdiction agreement, but also exclusive jurisdiction in the true sense of Article 24 jurisdiction. And if one thinks back to the authorities in this jurisdiction, where there would be Article 24 jurisdiction if the case was here, or if there was an exclusive jurisdiction in favour of the member state court, that would be the sort of classic case where you could have a reflexive application of the recast regulation in favour of a court of a third state. Now, in terms of dicey, I don't think we turned it up. My learned friend helpfully took the court to the passage which deals with the description of recital 24 containing a broad international concept underlying the general principle of lis pendens. But just before Dicey says that, there's a reference and an emphasis on the breadth of the guidance given at recital 24. And Dicey then goes on to say that it is for the court of the member state to determine for itself what is necessary in the proper administration of justice. And when one talks about international concepts of sort of lis pendens, one can see from Article 24 that the list of features there will be familiar to a court here as it would be in other European jurisdictions. One is looking to the expense already expended in the proceedings in the third state. To what extent have they progressed well beyond the proceedings in the second seized court? To what extent is it more appropriate? Are there stronger links with that first state which would make it appropriate to stay in favour of the third state court? These are familiar concepts. And one has to distinguish in my submission between importing forum context and considering lis pendens, because they're different concepts. It's correct to say on the basis of a wuzu, one can't just import forum concepts into the recast regulation, no. But you can look at lis pendens, which is addressed in the regulation. And certainly under domestic law, the sort of factors that one is looking at for lis pendens overlaps considerably with the factors that one looks at in terms of...
I was going to say, there's
very little between them.
Inevitable overlap, isn't there?
Yeah, it's almost complete. There are certain features, obviously, with lis pendens when one is looking at specific features of the proceedings in the foreign court, but other than that, they're extremely similar concepts. And so where you've got the two domestic authorities that my learned friend took the court to earlier, which is Gulf International Bank and Wardwood, and also the Fundeo Dam disaster case, they both refer to the concept of forum convenience and how one can look at those factors when interpreting or when applying Article 24. And my note of caution would be, well, yes, but only because, if you like, the factors overlap. One is looking at lis pendens rather than forum conveniens. But to the extent that there are factors within forum conveniens or lis pendens principles which would be relevant to the court's consideration of whether it's necessary to stay, then of course the court is entitled to consider them under recital 24, because that's what it says the court can do.
Sorry, could you just remind me what the page reference to Dicey was?
The page reference to Dicey is page 203
Thank you.
of tab 8.
Thanks very much.
So, in our submission, given what recital says and how the commentators fairly sort of unanimously interpret it, and the courts of first instance have interpreted it here, we say that it's simply for this court to take all the circumstances into account, and there can be no justification for restricting the relevant circumstances to those which point or are related to the third state court, as opposed to links which may point towards the member state. I mean, in our submission, it's not necessary, but it's also illogical for the court to consider things in one direction of travel only. The court has to look at the picture and around and consider both positions. We also say, in response to the point that recital 24 only refers or gives specific examples of connecting factors to the third state court. I mean, that is true insofar as it goes, but we would also say, well, it's utterly unsurprising, given that the connections to the member state court are going to be pretty obvious, and not only that, but assumed, because the member state court will have jurisdiction by one means or another. There's going to be a connection of domicile, there's going to be a connection related to either the parties or the substance of the case, which will justify the court having jurisdiction in the first place. And so in those circumstances, one can see why recital 24 would raise points which do not fall within the sort of jurisdictional analysis that the court would be carrying out in any event. So we say the judge didn't commit any error of law principle in looking both ways. Now, the next criticism, I think, of Perform is it says there's been interpretive error in having regard to the existence of the non-exclusive jurisdiction clause. It was also said in the skeleton, I'm not sure it is repeated orally, that recital 24 refers to an exclusive jurisdiction agreement, but not to a non-exclusive jurisdiction agreement, and this must have been a deliberate choice. Again, we say, it's the same submission, you can't say this court is not permitted to consider a non-exclusive jurisdiction clause in its favour, because firstly, it would be illogical to do that, given it would evidence the parties' contractually, if you like, selected venue, but also because Article 24 specifically allows the court to take all of the circumstances of the case into account. And if I'm right that recital 24 does refer to an exclusive jurisdiction clause in favour of a third state, and not just to the equivalent of Article 24 jurisdiction in the third state, it is referred to because that is a situation where the recast regulation would recognise that there was a good reason for staying potentially in favour of the third state court. I mean, it's a sort of classic case where the regulation would have reflexive application, but it would also, in my submission, respect one of the other principles of the regulation, which is autonomy of the parties. And so if the parties had concluded an exclusive jurisdiction agreement in the courts of a third state, then that would presumably be a persuasive element for the court, or matter for the court in considering whether to stay in favour of that court. But we also say that one cannot extrapolate from the fact that only an exclusive jurisdiction agreement is potentially referred to in recital 24, than a non-exclusive jurisdiction agreement in favour of the member state is not relevant to the article or the recital 24 assessment. I mean, obviously it provides the connection with the parties and to their legal relationship. It demonstrates consent. It also demonstrates an agreement to submit to the jurisdiction of the member state court. Do also say is relevant, because that is what the clause says, and that is what jurisdiction clauses often say. But it may also demonstrate that the parties appreciated and were prepared to tolerate the risk of fragmentation. So they were prepared to tolerate the risk of parallel proceedings, because if parties are not prepared to tolerate that risk, then they very often enter into an exclusive jurisdiction clause, which would provide a basis for preventing it. And if my learner friend is correct, because obviously the fact we're looking at any of this at all proceeds upon the hypothesis that Article 33 does apply, contrary to my primary submission. So if we're looking at this, then my learned friend has won, and we're into to ground 2 because the court has concluded Article 33 applies. We said it just because Article 3 would apply in this case, it doesn't follow that the court can't consider the existence of a non-exclusive jurisdiction clause when considering whether to stay. Because just because you can't stay where there is a non-exclusive jurisdiction clause, just because you can stay where there's a non-exclusive jurisdiction clause because Article 33 is engaged, it doesn't mean that its existence is irrelevant to the court's exercise of discretion in deciding whether or not to stay in favour of the third state. There are then a sort of miscellaneous...
Yeah, I mean, what would the position be if, let's say, jurisdiction is founded on the basis of domicile against the defendant? So we're into Article 33, but in fact the agreement had provided for the non-exclusive jurisdiction of the courts of the state of Delaware. I mean, would it be completely irrelevant to the assessment of the proper administration of justice that the parties entered into a non-exclusive jurisdiction agreement for the third party court to have jurisdiction?
No, it wouldn't be irrelevant. It would be relevant. If it's relevant when it points towards us, it's relevant where it also points to someone else. The risk of fragmentation or the appreciation of that risk is the same, whether it points towards the member state court or the third state court. And in the same way that if parties have said, we are prepared to be sued in that court over there, and someone has been sued in that court over there, then that is an indication that should be relevant. It's not necessarily determinative, but it's a relevant matter, obviously relevant matter for the court to take into account. And really, there is then a sort of, I was going back to my submissions. Perform then relies on a sort of miscellaneous sort of lump of other matters which they said shouldn't have been taken into account, such as English law, the relevance of English law. These are not matters clearly which one looks at the judgment. The judge placed a great deal of emphasis on, but they were in the mix, as were the connections of the two parties to the United States, which he fully appreciated. The court may have seen from the barrage of material in the supplemental bundle that there's all sorts of printouts and all the rest of it from web pages indicating that Ness is part of a global corporate group and its management is in the United States and that kind of thing. And so it may be. But it simply, in my submission and what the judge found, was not determinative at all in a case such as this. And particularly where one considers that none of the facts had any connection at all with the United States. It was all about Slovakia. The evidential keys to this case will be found in Slovakia, not in England, and not in the United States. Although there are some connections with England, given Ness is here, has directors here, has employees here, and runs the account from here. So, I mean, in our submission, the judge certainly didn't fall into any error in taking anything relevant into account. And if this court is not able to find an error of principle, it shouldn't then seek to disturb his exercise.
If you look at the fact that the circumstances of the case may include connections between the facts of the case and the parties in the third state concerned, that's that evaluation is one which may very well involve saying, well, that there is no real connection between the facts of the case and the third party state, but there's quite a big connection between the facts and the member state.
Exactly, which is why it's illogical just to say
It's completely illogical to say, well, you can have regard to the one, but you can't effectively have regard to the other.
Because as if it's relevant.
Because you'd be straying into sort of forum convenience territory. I mean, it's
simply a question of taking into account relevant material. If it's relevant that the facts connect to the third state, it's relevant that the facts don't connect to the third state, but also that they do connect to another state, a member state or a completely different state. There's simply no way you could do the exercise rationally or fairly by simply looking in the direction of the third state and ignoring everything that went the other way to the member state, but also the member state, but to any other jurisdiction which may have relevant links because that is relevant to how one assesses the strength of the connection and the desirability of staying in favour of a third state. So, I mean, in my circumstance, the factors indicated in recital 24 are obviously relevant, and are obviously things that the court should consider, but it's by no means the limit of what the court can and should consider. And the recast regulation foresees that there may be a myriad of different circumstances which may come up and which may affect the position, and it leaves the responsibility of working out what is the sensible thing to do to the national courts. And that is the way the Article 33 and Article 34 discretion has been structured in this case. And that's a notable deviation from sometimes within the regulation where they try and prevent really sort of any element of discretion coming in, so that when one is looking at predictability, you can tell it precisely where you're going to be sued. That's not been the approach that's been adopted in these two articles. It's one of the few places, I think, probably the only place in the regulation where that approach is actually taken, of affording discretion. And that's probably also why it's referred to by Briggs or Dighty as a sort of case management tool, rather than an allocation of jurisdiction, properly so called. So, unless I can assist the court further, I could make submissions on ground 3, which is whether it's appropriate to stay, but...
Well, I think it's accepted that it stands or falls with the other ground, isn't it?
I believe so. Yes.
Thank you very much, Mr. Thank you. Mr.
Lady, my lords, I will be brief, so we certainly will not be taking too much time. And I certainly don't want to trespass in repeating what I've already said, but I will try and do it in the context of reply, certain points that I do need to come back to. Now, just in terms of the overall picture, the court has made a very clear indication, and I understand why, that it finds unattractive the proposition that where you have non-exclusive jurisdiction here and parties domiciled, the defendant domiciled in France, you can't exercise, where you're sued here, you can't exercise Article 33 jurisdiction. But where the non-exclusive jurisdiction is at the place of domicile, you can exercise Article 33. And the court finds that a difficult proposition to comprehend as a matter of general logic. My answer to that, my lady and my lords, is the one I've already put to the court, but forgive me for repeating it in reply, which is, it depends on how you define party autonomy in the context of the regulation. And I have taken you to the POCAR report and how it views a non-exclusive jurisdiction clause. Which is that it confers additional jurisdiction to those objectively conferred under the regulation. What was said is that you should not read that too literally, in effect. And in my submission, the words mean what they say and are very clear. So, from a regulation perspective, in the scenario where the non-exclusive jurisdiction is England, it is serving a function of conferring jurisdiction where jurisdiction does not otherwise exist under the regulation, whereas in the other scenario, it is not. And that is the distinction. I made that an opening, and I apologize for repeating it, but I feel I do need to repeat it in the context of the arguments, particularly when the POCAR report and what it said is said not to mean what I have submitted it to mean, or at least shouldn't be taken as literally as that. In the case of where there is no domiciliary jurisdiction, there are no objective grounds of jurisdiction, other than the non-exclusive jurisdiction clause, POCAR is not dealing with that situation per se, but the answer is very clear under the regulation, which is that Article 6 says you can use a non-exclusive jurisdiction clause to confer jurisdiction even if there is no domicile. So that's the first point I wanted to make. The second point is that there's a general point being made that my interpretation goes against the role of domicile, which is to anchor jurisdiction within a member state. But I submit that that's not a correct proposition, because the regulation itself says attached to domicile is the domiciliary right to stay the proceedings in favour of a third state. So the fact that you're anchored here by reason of domicile is not a reason for saying it's counterintuitive to say that you can stay the proceedings, because that's exactly what Article 33 is doing. It's saying that a defendant domiciled in this jurisdiction has a domiciliary right to stay. That then gets into the one of the key nubs of the difference in interpretation between myself and my learned friend, which is my learned friend has said that there is no problem accumulating jurisdictions at the same place. There is no problem. In other words, you can have concurrent jurisdiction at the same place. And I've already addressed this in opening, and so I don't want to restate it, but I don't accept this proposition of accumulation of concurrent jurisdiction at the same place. So Article 4 read with Article 5, and I understand what Lord Justice Henderson and Lord Justice Flo put to me about subject to this regulation. My answer has always been and remains, well, subject to this regulation includes Article 5. Article 5 says that you apply the other rules of jurisdiction at places other than domicile. And the reason why I accept an exception to that is simply where there is a superior rule, because of the fact that recital 15 says that domiciliary jurisdiction should always be available save in certain limited circumstances relating to subject matter and party autonomy. So when you read Article 5 with the recital, my point is simply that you then have to accept that there is a limited exception to the scope of Article 5. So that jurisdiction would not be based on domicile, where you have a superior rule such that it is no longer in substance available. So in my submission, it's not about saying that I'm trying to bring into Article 33 a distinction between exclusive and non-exclusive jurisdiction clauses. In my submission, I'm not bringing in a distinction in Article 33. What I'm doing is identifying the circumstances in which the relevant clause is engaged. The point.
What I still don't think you've really answered, I may be wrong, is which provision in this regulation you say makes the difference between a non-exclusive jurisdiction clause where the parties are domiciled in the member state, as in this case, and an exclusive jurisdiction clause, which you accept would, if this jurisdiction clause were exclusive, Article 33 wouldn't apply.
Yes, my lord.
But what I don't understand is
Yes.
how you draw that distinction from the wording of the regulation.
Well, apologies, my lord. I'll try it one more time, and I understand the difficulty that you're having with it. But I derive that from Article 4 and 5. And let me explain what I mean by that. As I've said, we get into the regulation through Article 4. And then once we get into the regulation through Article 4, because we're not in an Article 6 situation since there is a domicile here, Article 5 says persons domiciled in a member state may be sued in the courts of another member state only by virtue of the rules. So Lord Justice Henderson's point to me is subject to this regulation, brings within the regulation everything at the place of domicile. My contrary interpretation is that is not the way I put the interpretation of the regulation. Rather, when you're in domiciliary jurisdiction under Article 4, you go to Article 5. Article 5 tells you that you can use the other rules of jurisdiction in places other than the place of domicile. And that was also consistent with one of the recitals that I referred your ladyship and your lordships in opening. What that means, why I accept, therefore, as I've obviously failed to explain coherently enough, is that why I accept that in an exclusive jurisdiction under Article 24, or an exclusive jurisdiction clause prorogated jurisdiction under Article 25, that they nevertheless mean that jurisdiction is not based on domicile at the place of domicile is, I read Article 5 as subject to a teleological exception as a matter of the intention of the drafters, given that where there is a superior rule, according to the intentions as indicated by the recitals, domiciliary jurisdiction is no longer available. And the question is, when is it no longer available? I've explained how within the hierarchy of the rules, there is no trumping, in my submission, of a non-exclusive jurisdiction clause over domicile. They're on parity. And therefore, the exception to be read into Article 5 does not extend. It is non-exclusive. So that's how I get there, my lord.
All right.
A point was then made about Article 7 and non-exclusive jurisdiction, but that really, in the sense that if you've got, if at a place you've got Article 7 jurisdiction and non-exclusive jurisdiction, then what is said is then jurisdiction is no longer based on Article 7, and the same therefore applies to Article 4. I've already dealt with that in opening, and my point was simply that, again, the non-exclusive jurisdiction clause does not serve a function under the regulation where jurisdiction is objectively already founded under the regulation. My lord, those are the only points I wanted to make on ground one.
Mm-hmm.
On ground two, first of all, on whether you can read all as meaning literally all, I've already made my point, which is that the examples given are examples concerned with the third state. What is then said, and what your lordship put to my learned friend is, well, when you're looking at those things in the third state, it necessarily brings within it a sort of comparative exercise. I don't accept that it brings in that comparative exercise in a forum non-convenience sense. and I've taken you to at least some material which supports the proposition that it isn't forum non-convenience under Article 33. So what one is asking is whether any of the matters that you're looking at affect the administration of justice in the third state. So, in other words, the fact that witnesses are all located here. So if one comes to the view, to take one example, that, well, what are the connections between the facts and the third state? And one concludes there aren't many. One has to start, in my submission, from the fact that there is a risk of irreconcilable judgments, which is to be avoided in the administration of justice. That's at stage 1. And the question is, well, does that affect the administration of justice in the third state, the fact that the witnesses are located here? And unless there's a difficulty in those witnesses being, the fact that the witnesses are here, unless there's a difficulty from an administration of justice perspective, and not just the interest of the parties, convenience, and so on, then in my submission, it makes no difference. And that's the difference that I am trying to put on the regulation as compared with a traditional forum non-convenience, all circumstances, take it all into account in the round. And finally, so in other words, I do submit it's a narrower concept than the concept that that the court has been putting to me. Now, the final point is again the non-exclusive jurisdiction clause. As I've said before, I don't accept that in recital 24 there's any reference to exclusive jurisdiction clauses as opposed to exclusive jurisdiction. So it's concerned with Article 24 jurisdiction. And I have great difficulty in the idea that if you've got through the based on domicile gateway of Article 33, that you can nevertheless have regard to the existence of a non-exclusive jurisdiction clause in circumstances where on that prior assumption one has taken the view that the non-exclusive jurisdiction clause has served no function under the regulation. In my submission, it would then, in those circumstances, make no sense for one to bring it back at the second stage. Unless I can assist the court further, those are my submissions in reply.
Thank you very much, Mr. Ryan. Thank you. Well, thank you both very much indeed for your extremely cogent and helpful submissions. Won't surprise you to hear that we'll reserve our judgment. We will provide you with a draft of the judgment in the usual way for you to point out any typographical errors and the like, not to invite us to reconsider what we may have said. In all likelihood, the judgment will be handed down remotely in the current circumstances, but if you could also endeavour to agree an order, and if you can't, for whatever reason, agree an order, provide written submissions so we can decide the matter on paper. Thank you very much again.
My lady, my lords, just to say it's a privilege to be here in person, having been...
Well, Mr. Dewan, I'm very glad you said that, because we did say to ourselves during the break that perhaps we'd intervened more than we would have done if we'd all been on a screen. And you might have felt hard done by as a consequence. Yeah, it really is. Whatever one says about remote hearings, and I think we've all done extremely well in the circumstances. There is absolutely nothing to really compare with. The reality is that.
It's not the first one. Yeah, I haven't had a remote hearing, an in-person hearing since last March.
Really?
Yeah, it's my first one for you. I was worried about.
I've sort of dipped in and out over the last 9 months, but anyway, let's hope that we're now on the road to some sort of recovery. Thank you both very much indeed, and those behind you as well.
Well,
45.